Please. Good morning. My name is Nangulu Ede. I am I'm the ULS Eastern Council member. I bring greetings from the council. I bring greetings from the president to each of you that is joining us from wherever you could be this morning. To our special guests, Professor Christopher Mbazera, Mr. Amos Kuku, Ms. Cleopatra Abikira, the ULS council members joining us online, the ULS members joining us physically and online, members of the press, ladies and gentlemen. Allow me to say good morning again. It is a fairly chilly morning, not flooded, a bit chilly. I bring you again greetings from our president, currently serving us and representing the Radical Nuba in Malta, together with our vice president. You're most welcome to our 13th series of the RNB Weekly Press and Public Engagement. We discuss usually matters of public concern and key topical issues. We deeply appreciate your presence and your commitment to this journey with the Radical Nuba. Today, we have two key topics. We are still celebrating the release of our brother Eron Kiiza. So we shall be discussing a topic on that. The topic is on the horns of a dilemma, analysis of the Eron Kiiza case. We have a distinguished panel that has a lot of depth and wealth to break down. I always have our president say, break down something into soluble pieces for members to appreciate. So we're hoping we shall break down these cases here. The second topic is the rise of young legal explainers in the online era. We also have a distinguished panel of young legal persons to also break that down for us. They'll be guiding us through each of these topics. So I want us to set today in motion. Allow me to invite our moderator, Mr. Robert Jarua, to take us through the next session, please.
Thank you so much, Council Eddie Nangulu. I will stand on the protocol observed. I greet you all in your various capacities. I'm going to take us through a brief synopsis of the issues at hand that are going to be discussed today. We thank you once again for the panelists who have made time to take us through these. On issue one, on the horns of a dilemma, analysis on the Eron Kiiza case, a brief discussion and a brief introduction is as follows. On the 7th of January 2025, Advocate Eron Kiiza was arrested while representing Dr. Kiiza Besigye and Haji Obeid Lutale at the General Court Martial in Machindye. He was convicted of contempt of court and sentenced to 9 months imprisonment at Chitalia Prison. And on January 31st, 2025, the Supreme Court, the highest court, made a landmark ruling in the case of the Attorney General versus Kabaziriguka Constitutional Appeal number 2 of 2021, where the court held that the trial of civilians in military courts was unconstitutional and ordered for the transfer of all such cases to civilian courts. Following several legal challenges, including but not limited to a failed habeas corpus application, Eron Kiiza was finally granted bail on the 4th day of April 2025 with a cash bail of 20 million shillings. This case is still ongoing and it raises questions of rights on the rights of advocates to do their work without fear of persecution. Others have questioned whether cash bail conditions promote justice or create a barrier to it, especially for those who cannot afford. As we unpack this case, we ask, what does it reveal about the state of justice in Uganda? What precedent does it set for the legal profession? And what role do we as lawyers, civil society, and concerned citizens have in upholding the rule of law in such circumstances? Now, to help break down these to soluble pieces, like the president says and the secretary has just said, we bring forth unto you legal brains that are tested and proven, and one of them, who we are going to have today, is a professor that holds an LLB from Makerere University, an LLM in human rights from the University of Pretoria, and a PhD from the University of the Western Cape in South Africa. In 2015, he was a co-recipient of the Vera Chirwa Award given by the Center for Human Rights, University of Pretoria, for his outstanding contribution in the promotion of socio-economic rights in Africa. He is also a professor of law at Makerere University. He is the coordinator of the Public Interest Law Clinic, that is PILAC, and a founding member of the Network of Public Interest Lawyers, that is NEPTIL. Since 2018, he has supported the National Planning Authority in integrating the human rights-based approach in the country's development agenda. He has done several consultancies in international agencies, including but not limited to the United Nations on human rights and governance matters. For some of us who have been privileged, he has also been a teacher or a lecturer to us at the School of Law, Makerere University. Ladies and gentlemen, I bring forth unto you Professor Christopher Mbazira. Thank you so much.
Thank you so much, Mr. Moderator. Good morning, ladies and gentlemen. Thank you so much, Council Member, Council Nangulu. Special tribute to the President. I know the President is online. We know wherever you are serving the Rnblive. We appreciate that, as well as the Vice President and other members. A special appreciation to colleagues that are following this online. Of course, we cannot forget the Secretariat for the consistency, consistently arranging this. It is something that has come with a new era, and it has indeed had an impact, because we need spaces of this nature. And one thing I appreciate about this space is the diversity. It is diverse, looking at various subjects that are relevant to the legal profession. We really appreciate that, and we encourage the Council and Secretariat to continue with this. It's a pleasure to be here, to be speaking to something that is topical. Of course, I speak on this in various capacities. I may not be able to enumerate all, but I speak on this one as a law scholar. I speak on this too as a legal practitioner. I speak on this as somebody that is passionate about rule of law, access to justice and independence of the legal profession. I speak to this as one of the actors that have followed closely and been part of the processes touching on the case of Eron and other situations. And of course, I can't forget, I speak to this also as a candidate for the Judicial Service Commission, as you know. And of course, I represent legal scholars here, but remember, I also represent border riders. Please don't forget that. The border rider being the Omuntu wa wansi. Earlier, somebody was asking where the border is. The first border was stolen. But be sure that I've replaced the border, and very soon it will be hitting the road. Yes, I was invited to speak to the topic which reads on the horns of the dilemma, analysis of the Eron Kiiza case, that is the subject that I was invited to speak to. In the first place, I'm not sure I want to call it a dilemma, because to me it is bigger than a dilemma. A dilemma is a small thing. To me, a dilemma presupposes a situation where one is faced with two undesirable choices, and most times not self-inflicted. You could, of course, have contributed to the creation of the dilemma, but it comes where you are faced with two or more undesirable choices. To me, it's actually a crisis. We are looking at a crisis. We are faced with a crisis. What is a crisis then? A crisis is an unstable state of affairs with the distinct possibility of a highly undesirable outcome. And I think that's what we are facing. And while crises sometimes arise from acts of God or other factors over which man may not have control, many times crises can also be man-made. And in our case, we are looking at a man-made crisis. We need to understand that. So I'm adjusting the topic a bit. I thought dilemma is a bit simplistic. The problem is much bigger than that. It's a crisis. So in my view, the Eron case, while it has created some dilemmas, it is largely part of a bigger crisis. What is the crisis then? The crisis that we are facing is a crisis of democracy, it's a crisis of politics, it is a crisis of rule of law, it's a crisis of access to justice, it is a crisis of the judiciary and the legal profession. That's the crisis that we are facing. Specifically, when we look at it as a crisis of our justice system, and of course, the key players there are the judicial officers and the members of the bar or practitioners. When we look at this case as part of that crisis, we are looking at the judiciary in a crisis, which is a crisis of rule of law. Justice is in a crisis. And I will elaborate some of the manifestations of that crisis. Recently, I was doing some readings, looking at the science of crisis management. And what emerges is that there are various principles and phases that are followed in managing crisis. But I picked out principles that define 5 phases of managing crisis. The first phase is phase 1, early warning and signal detection. Do we know that a crisis is likely to happen? The second one is preparation and prevention. The third phase is damage containment. The fourth phase is recovery. And then the last phase is learning and reflection. And I'm going to show how each of these phases, not that all have manifested, but I'm going to show how some of these phases have manifested and how the Kiiza Eron case then comes into play. But of course, first of all, before I go through the phases, it is important that we understand how the crisis of justice has manifested. What are the indicators of this crisis? Number one, of course, corruption has been a long-standing indicator of the crisis in the judiciary. And of course, to be objective and open, as a profession, we are not totally innocent as far as fueling the corruption is concerned. The other indicator of the manifestation of the crisis in the arena of access to justice is delays in dispensing justice. And we've seen this, I'll touch on that later. We've seen this in the Eron Kiiza case. Again, in some respects, as so many surveys have demonstrated, as a profession, we also have our share in fermenting this indicator. But more fundamental for me and the crisis that we are facing now is the crisis indicator one, disregard of human rights. Blatant disregard of human rights, including by judicial officers. And sadly, this has included disregard of non-derogable rights, because sometimes disregards of human rights may be justified as a part of justifiable limitations, but when it comes to non-derogable rights, the issue is quite different. So including disregard of non-derogable rights, including fair trial, freedom from torture, and the like. For instance, we've seen so many cases, and the other day somebody was making a comment publicly that we've seen instances where, for instance, judicial officers disregard the fact that an accused person is dripping with blood, with wounds of torture and gashes, open gashes on their body. But the judicial officer disregards that and actually continues trying an accused person. The other manifestation of the crisis is disregard of counsel privilege. And but this, of course, goes with the right to legal representation. We've again seen this in the Eron Kiiza case. One of the very important facets of the right to a fair trial is the right to legal representation. And the right to legal representation cannot be actualized if the legal profession is not accorded certain privileges. You may want to know that in some countries, actually, lawyers are not arrested even for offenses they commit in their private capacity. The procedures for their arrest is different from the procedures of arrest of ordinary people. For instance, in some countries, the president of the bar has to be notified, and there are processes that have to follow. Not that the law is shielding counsel from the incidents of criminality, but it's because the profession is so key in guaranteeing the right to counsel and the right to a fair trial. The other manifestation, there are quite many, but I'm going to end with this, is the unpredictability of outcomes of judicial processes, court hearings. You know, you go to court, of course, in a court process, there must be an element of unpredictability, but largely based on precedent, based on principles of the law, one should be able to predict and actually properly advise their client whether or not they have a case. If they don't have a case, you should be able to advise on the mitigation measures. But increasingly, what we are seeing in our judiciary is that judicial outcomes are unpredictable. We see blatant disregard of precedent. We see blatant disregard of express principles of the law. And shamelessly, we see disregard of precedent sometimes from the same judge without any justification. We are not saying you cannot depart from your previous decisions. But as you depart from your previous decision, there must be justification for that. So those are some of the indicators of the crisis that we are facing. And indeed, we see most of these indicators in the Eron Kiiza case. As I've said severally, I have spent the last 2 years writing a manuscript for a book which I have entitled Constitutional Transformation, Judicial Power and Politics in Uganda, Walking in and Outside the Constitution. This research has really given me the unique opportunity to delve into the crisis that we are facing, to delve into the inhibitors of constitutional transformation, judicial-driven constitutional transformation in this country. The manuscript is ready. I've already submitted it to a publisher for obvious reasons. I will not disclose who the publisher is, but I'll be sure very soon the book will be available. Now, I want to go back to the phases of crisis management that I've mentioned above to help us analyze the crisis that we are facing. Phase one, remember, I said, is have early warning signals. The question then is, have we as a country, have we as a profession had early warning signals? Indeed, we have, and from my research, some of these signals are historically rooted, mainly rooted in the fact that the colonial state looked at or used or conceptualized the judiciary as a tool for domination, as a tool for social control in so many respects. I don't have time to break it down, but the criminal law, the procedures, the imposition of an alien system, etc., etc. Unfortunately, to a certain extent, this has been inherited by the current, the post-election, the post-independence political dispensation. So what this then has resulted into is to have a judicial body or a judiciary which is largely used as a tool of domination, a tool of political and social control. And this is where the RNB object of decolonization comes in. We have to decolonize. Of course, historically, the warning signs stretch as way back as ex parte Matovu, a case which is known to all of us. I'm not going to go into the details of each, but of course, we need not be blind to the sometimes momentary, delightful moments of judicial functionality in some respects. We've had some cases where the judiciary has risen to the need to be transformative, but largely it has retained that colonial character of being a tool for social political control and domination. But the warning signs, as I've mentioned, are very, very clear historically, but they continue. How then do they manifest post-independence and in the current dispensation? Number one, we see open preference for cadre judges. One will ask me, who are cadre judges? Please wait for my book. It breaks down who cadre judges are. Not by name, but it breaks down the concept of cadre judges, because the political establishment has been very open about it, and there are so many, there's a lot of evidence that proves that. The other manifestation of the crisis is the opaque system of judicial appointments. That one we know, we've spoken about it in the campaigns for the to represent the ULS on the commission. We spoke about it several times. Number three is the lack of a system of accountability by judicial officers. Judicial officers think that they are only accountable to appellate courts. That's why you see, even when they make an overtly wrong decision, they will always say you can appeal. They don't feel accountable to the public. They don't feel accountable to the parties. They don't feel accountable to the profession. They only feel that they are accountable to appellate courts. That's a very serious manifestation. Colleagues, you may remember that when I unveiled my manifesto for the bid to represent you to the Judicial Service Commission, I emphasized the need to build a system for evaluating the performance of judicial officers. And I indicated that this system would, among others, have a scoring system where we score the performance. And among others, it is this system that would inform promotions of judicial officers. Of course, these were my ideas, but then later other candidates picked them up. They picked up this and they started parroting it without understanding its nuances. We may want to remember that. Number four, manifestation of the crisis is increasing intolerance to criticism. A rise, of course, connected to the feeling that their judicial officers are not accountable. And unfortunately, this has trickled right from the top bench to the lower bench. Of course, there could be exceptions here and there. We don't want to detail those here. We don't have time. But generally, that's a manifestation of the crisis that we are seeing. And of course, we see that one of the tools that is now being used is contempt of court, which we need to deal with. Phase number two, remember the phases I'm talking about, the phases of crisis management. Phase number two is preparation and prevention. Once we have the early warning signs, once we have the manifestations, before it manifests, or if it has already manifested, how do we prevent further escalation of the crisis, or if not yet, how do we prepare? Of course, there are indicators of this to a certain extent. Number one, guarantees in the Constitution. We have a Constitution that guarantees judicial independence, that has a Bill of Rights, that guarantees civil rights, including non-derogable rights. But of course, it also has its weaknesses. One of the key weaknesses that we need to consider as the Rnb and the profession, there is a bit of a lapse in the composition of the Judicial Service Commission. If you look at the historical factors, the exclusion of the Chief Justice and the Deputy Chief Justice as members of the Commission. Right now, and for a long time, the Commission, the previous Commission was chaired by a High Court judge who was deputized by a Supreme Court judge. What an awkward situation, and we are likely to see that in the future. So that is something that we need to keep on the radar. The other preparatory indicator that we see is the statutory mandate of the profession. The profession is a statutory body. Its mandate is clearly defined in the ULS Act. Its mandate is clearly defined by international standards that, among others, guarantee the independence of the legal profession. Those are some of the prevention measures that the law puts in place. But of course, we've also had a crisis in the profession to a certain extent. The crisis has also manifested in the profession in spite of those guarantees. One of the manifestations of this is that the profession has not been consistent in pushing back on the indicators of the crisis that I've enumerated. Some sections of the profession have been passive, and for a long time, they have been passive. Of course, we cannot gloss over those moments where the profession has pushed back. You remember the 2005-2006 boycott. The problem, though, has been one of consistency, which has pushed us. We have had moments where we should have reacted in a more radical manner. We've not, up to a point where we gravitated into a society of statements, where we have serious incidents, serious happenings that require certain radical reactions, but we issue statements. The other shortcoming here is that for a very long time, of course, we've not been able to effectively influence judicial appointments because the profession was robbed of its representation to the Judicial Service Commission for a very long time. The Rnb comes in after the Kalari case to try to get back our right to influence judicial appointments, but we know that again we've faced situations where the same is being robbed again. Phase 3, which is damage containment. This is what the Rnb is doing, damage containment, and several strategies have been used, including this forum that we are addressing now, including the executive orders that have been issued, including firing up the profession, mobilizing the profession in many ways, including having the public on the side of the profession. But of course, there are forces that are pushing back. There are forces that are pushing back that we have to contend with as we democratize, decolonize, and demilitarize, as well as digitize. We have forces, for instance, that want to continue robbing the profession of its chance to influence judicial appointments, but we need to remain steadfast in this regard. Phase number 4, recovery, and this is for the future. What we are investing in now is to contain and recover from the crisis. The crisis is still unfolding. The crisis is still unfolding. We need to be consistent. We need to be firm to be able to recover, and then later we can reflect on the lessons and the lessons what we learned, which is the last phase. So with that background, as I conclude, I now want to delve into the case. I had the opportunity to provide leadership to the Eron litigation team and to be part of the defense team, and I was able to follow a number of things that were happening. Remember what I said? I said the Eron case is part of a bigger crisis. The case itself has been a crisis and has had so many dilemmas. Now, the crisis in the Eron case manifests in the following ways, or in the following stages. Number 1, it manifested in the General Court Martial. Number 2, it manifested at the Supreme Court. Number 3, it manifested at the High Court. And the High Court had 2 subplots, as the moderator has educated us. The manifestation in the civil division, and then the manifestation in the criminal division. I'm not going to say much about the manifestation in the General Court Martial. The Kabaziguruka case is very clear. The failure to follow basic tenets of independence of a judiciary, of a court of law, disregard of basics of a right to a fair trial and the like that are canvassed, but also specifically how the court managed the Eron case. Throwing a person in, sentencing a person in jail, counsel without a formal hearing. There is no formal ruling, disregarding even the provisions of the law that the so-called court was following, and doing things in a blatant and arbitrary manner. Let me touch a bit on the crisis in the Supreme Court, the Kabaziguruka case. Because the Kabaziguruka case, as much as the principles are good, we welcomed it, fair trial, the fact that the General Court Martial and other military courts lacked the tenets of a court of law, independence of the judiciary. But the Supreme Court decision also fermented the crisis. How did it ferment a crisis? When you look at the orders of the court, to a certain extent, they were very clear as to who would benefit from the decision, the inconsistency of the law with the constitution, who would benefit and who would not. But the court fermented the crisis by not giving very clear directives. And it missed the opportunity to do that because it never retained jurisdiction. What is the practice? The practice in cases of that nature, where the court pronounces itself on unconstitutionality, but is not certain or does not have the information as who is affected. The practice from other jurisdictions, and to a certain extent we've experimented with it here, would be for the court to retain jurisdiction, would be for the court to issue a structural injunction. This was a case that was ripe for a structural injunction, where the court should have retained jurisdiction. It should have ordered the Attorney General to provide information on those that are affected within a specified period of time, and it should have have retained its jurisdiction to give further directives. I know we've started the process, and some letters were written for consequential orders. Responses are yet to come from that, but all that would have been avoided had the court retained jurisdiction. Within a short period of time, depending on the time, the court would have prescribed it, would have gotten the information and then given very clear directives that are intended for the benefit of clearly specified individuals. That didn't happen, and that's how we've somehow faced this crisis. Now, the crisis in the High Court, as I said, manifested at the civil division. I know most of us could have read the decision of His Lordship Justice Kiiza. How does it foment a crisis, a bigger one, and it's not the first case? Increasingly, what word should I use? Debasing habeas corpus. You know, habeas corpus is one of those legal processes that have traditionally been treated with urgency, that have traditionally been treated in such a way that ultimately the person seeking relief is accorded the relief. So when a judicial officer begins to play around with habeas on technical grounds, administrative divisions in the judiciary, that is fomenting a crisis. By the way, you may want to know that actually originally habeas corpus was not in our constitution. Many lawyers may not know that. When you read the 1962 constitution, it didn't have the right to habeas corpus. Habeas corpus comes through the case of Ibingira. So it is the judiciary that historically introduced habeas corpus in our legal system. And it was after the Ibingira case that actually habeas corpus was constitutionalized and put in the constitution. So it's unfortunate that the same judiciary should now be undermining habeas corpus, which is expressly constitutionalized. So that was really a crisis. When you read the decision of Justice Kiiza, one of the reasons he gives is that, you know, it would be misusing judicial resources if people were allowed to go to any division. So this is civil division. Maybe this should have... if the judge expended judicial resources to make that decision, only to push the case to another division, which also expended resources, material and time, who was wasting the resources? It is the judicial approach itself that was actually wasting the resources. Then, of course, we see a crisis somehow mitigated in the criminal division, but behind the scenes, actually, there were a number of issues that somehow fomented the crisis, mainly the delays, the reluctance of the division to take up the case, etc. What do we see now? As much as bail was granted, I know one of my colleagues is going to speak to the conditions that were imposed. That is the cash bail, but my colleague will speak to that. Lastly, again, in the case manifests the crisis arising from the way bail applications are being treated. Traditionally, bail applications are supposed to be had instantly. Actually, you can make a bail application orally. But increasingly, we see that bail applications are being formalized, that there has to be a formal application, there has to be submission, there have to be adjournments to hear, to give the state the opportunity to respond, and then adjournments for submissions to be filed, and then adjournments for a ruling to be delivered. Traditionally, bail applications are not supposed to be considered like that because they are speaking to a non-derogable right. They are looking at the liberty liberty of an individual has to be treated as a matter of urgency. So, ladies and gentlemen, that's how we see the crisis. It is an unfolding crisis. You could see the crisis that the Supreme Court created. Justice Elubu tries to delve into it. Where do you appeal? Where do you file your bail application? Which court has jurisdiction over you? Who is affected? And things like that. But of course, the judge tries to manage the crisis by using the inherent powers of the court. So, colleagues, ladies and gentlemen here, colleagues online, we are faced with a crisis of justice. We are faced with the crisis of rule of law. We are faced with the crisis in the courts of law. We are faced with the crisis in the profession, but we need to remain steadfast. We need to remain consistent. We need to embrace the Rnblive, not forgetting that we've committed to democratize, we've committed to decolonize, we've committed to demilitarize, and we've committed to digitize the profession so that we are able to recover from this crisis. For now, I'll leave it at that. Thank you so much for listening to me. Don't forget that I'm your preferred candidate to represent you at the Judicial Service Commission. Very soon the border will be reaching you. Thank you so much.
Thank you very much, Professor. Ladies and gentlemen, and those online, of course, we cannot appreciate more with your in-depth analysis of the matter. We thank you so much for the opportunity to hear from you. We shall also remind the audience that you are a representative of Border Borders, and we shall hope that the helmet next time will sit next to you, that you said you forgot behind. Thank you so much for being a proponent for the RNB. We appreciate the 4 Ds have come out clearly from what you've discussed, and clearly we can see that you are really a proponent for social justice, and we pray that God bless you in your endeavors. Ladies and gentlemen, we are still on the same track. Thank you very much. We have some more work to do and more breakdown into solubility of the issue to do with the Eron Kiiza case. Our next speaker is in the house. We thank you once again for coming in. We have an advocate of the High Court who holds a bachelor's degree in law and a postgraduate diploma from the LDC. He has a very keen interest in upholding human rights, law, and social justice. He's a fellow of the East Africa Public Interest Advocates Program. In his work around public interest litigation, he has earlier on filed a public interest case in the High Court challenging the constitutionality of the cash bail, stating that it violates the right of equality, the right to equality, and the right to liberty. Ladies and gentlemen, and those online, I bring forth unto you Advocate Amos Kuku. Thank you so much.
Thanks very much, Mr. Moderator. As earlier introduced, I'm by names of Cook Amos, a public interest lawyer with keen interest into rule of law matters pertaining to access to justice. And ladies and gentlemen, a very good afternoon. The bar, the legal fraternity, and the public and all members following online, protocol observed. Today's topic on the horns of dilemma analysis of Eron Kiiza's case, which I termed to be the unlawful detention and the bail scandal of Eron Kiiza. And we are called upon to analyze exactly the human rights implications of this case. Without further ado, we all know the synopsis of Eron Kiiza's case and where it originated from the case of Attorney General versus Kavas Guluka, where Eron Kiiza, doing his noble duty representing his client, Dr. Kano Kiiza Besigye, was arrested and charged with contempt of court contrary to Section 171 of the UPDF Act. As such, he was unlawfully sentenced to 9 months in prison. The plethora of exactly what followed, that is in the aftermath of Kavas Guluka case, was the habeas corpus application that was filed before the Civil Division. That is Eron Kiiza versus Attorney General and Commission of Prisons, where in the radical Nuba precincts, the judge grossed the law by alluding to the fact that entertaining that application would tantamount to causing judicial chaos, and as such, paid homage to formalism that they had used the wrong procedure, and the case was dismissed on the technicality. That gave rise to the bail application, that is Eron Kiiza versus Uganda, application number 118 of 2005, that of recent was granted by Land Justice Michael Elubu. That is the background of that case. What is the takeaway from the Land Justice's ruling as far as the bail application and adjudication of the same is concerned? For one, I celebrate that ruling simply because for the advocates of social justice, equity, and the Human Rights Court, the Land Justice found that a court did not have jurisdiction to entertain an appeal as it had been filed. As such, that means if you follow formalism, the bail application must have collapsed at that point. For the simple reason, court had found that it did not have jurisdiction to entertain an appeal for want of a law that grants jurisdiction onto a civil court on matters originating from the court martial. And in his wisdom, Justice Elubu Mike held that a court of law, that's the conundrum in the Kavas Guluka case, cannot grant jurisdiction on another court simply because jurisdiction is a creature of a statute. The proper thing to do was Parliament to enact the laws that would grant jurisdiction and procedural technicalities or procedural formalism on how these matters were to be entertained by the civil court, in this case, which is the criminal division. However, like in the ex parte matovo, because the rights of an individual, moreover an advocate who is an office of court, were at stake, court decided to employ Article 126 2E, disregarded all formalisms, and entertained the bail application, which was granted. Still, I celebrate the Land Justice for having granted this application amidst the political undertones and the executive overreach. The powers that be trying to subjugate the independence of the judiciary as far as these cases are concerned. However, it leaves a lot of questions, much as we celebrate the ruling. One, the terms upon which this bail was granted leaves a lot to be questioned, to be answered, to be advocated for. One, when we're entertaining these cases, we have the remedies in personam. To the members of the public, what the public gets from a judgment, that's the rules in rem. But in personam, what an individual gets. So these cases have gotten an implication on the general overflow of bail applications, access to justice, and access to bail relief. So when such terms are prescribed by court, it does not only touch to Eron Kiiza, but the general public. What shall be prescribed to the general public, because they leave a precedent which be binding on so many courts in Uganda. What were these terms in Eron Kiiza's case? Court held that the applicant shall execute cash bond of 20 million. Cash bonds literally means that for you to be released, you must deposit that in court or on the judicial account such that you're released. The second outrageous condition was the applicant shall be required to deposit his passport with this court in the event he requires it for travel. An application to the effect will be made before this court. Let me first summarily deal with the issue of the passport. A human rights court and a court of equity is holding that it was uncertain as to when Eron Kiiza's application appeal would ever be heard, because we don't know when Parliament shall enact such a law. He was convicted for contempt, an offense that didn't involve violence, if at all it even happened. Therefore, for all intent and purposes, there is unlikelihood that Eron would abscond or would escape from this jurisdiction. Why would a court of law retain his passport under the guise that if you want to travel, come and make this application? And on whose cost? If you're to hire a private lawyer, how much would it take for them to lodge that application? How long will it take for the application to be heard? As such, it leaves a bad precedent as far as access to justice is concerned for the ordinary Ugandan and the general populace. Those are bad precedents that we are retaining in the body of our case law. To lay some kind of a background about bail and these terms and conditions, we shall all recall that bail has been a subject of inconvenience to the powers in Uganda, calling on the judiciary to stop granting bail in specific cases. Actually, at time T, it was a blanket call that we should legislate almost to abolish bail. In politically contentious cases, still we shall recall that many times when accused persons are released on bail, they are rearrested, sometimes even within the midst of the court premises. And as such, many times court has stood helpless. It has happened so many times, including even the late Seglinya, may his soul rest in peace. That shows exactly how this right is fundamental and how it has been abused in our jurisdiction by both the stakeholders, that's the jail sectors, the judicial is often prescribing these terms and conditions, and those who hold power in Uganda by not believing that some people do deserve to be granted bail. What is the legal basis of these conditions? More so cash bail, because I summarily dealt with the issue of the passport. But cash bail itself, you find that the synopsis of bail in Uganda is Article 23, Clause 6. That allows a judicial officer to prescribe conditions as court seems reasonable. That one is key and is underlined because in all the clauses under Article 23, Clause 6, A, B, and C, the last word is court must deem those terms and conditions to be reasonable. It did not, the Constitution did not prescribe cash as a condition. It left it to the discretion of a judicial officer under a presumption that judicial officers would be deemed to be rational beings. Then we can also look at Article 14 of the Trial and Indictment Act, that's Cap 25. Still, it also grants powers to a court to prescribe terms, but is silent as far as cash is concerned. And also Section 78 of the MCA, that is Clause B, which specifically states that a court officer may, quote the word may, instead of taking a cognizance, that is a bond, allow a person to deposit a sum of money to such amount as the court or officer may fix in lieu of executing such a bond. Therefore, instead of you executing a bond, you might be required to deposit a particular amount of money. My observation to section 78 of the MCA. MCA is an act of 1971, and as always we have asserted, those are colonial hangovers. It's a law for colonialists, and I don't think that it fits within the dictates and precincts of the constitutional command as far as human rights and access to justice is concerned. Cash bail contestations in our jurisprudence in Uganda, because it has been a subject of contestations. Without wasting a lot of time, by the year 1997, in the case of Charles Onyango Bo and Andrew Mwenda versus Uganda, where they were prescribed to pay 2 million, only 2 million, for the offense that they had committed, they approached the High Court to revise, and it was reduced to 200,000. And the court held that a court should not impose such a tough conditions that on the whole bail looks to be a punishment to the accused. So the terms must be reasonable for it not to hinder or to act as a barrier of access to justice. We also recall the case of Kiiza Besigye. That is Kiiza Besigye versus Uganda, criminal application number 18 of 2022. This one is of recent. And it originated from Buganda Road, where the magistrate, by then called Sienna Owomugisha, prescribed that Dr. Kiiza Besigye had to pay 30M for the offense of inciting violence. This is a G1 magistrate, even under civil law, has no jurisdiction to entertain a matter which is beyond 20M. But she or he had the audacity to prescribe 30M. Kiiza Besigye went for revision, and this very same case was adjudicated, or it was entertained by the learned Justice Michael Elubu. I would wish to compare the two, Eron Kiiza and Kiiza Besigye's case. Very same judicial officer, earlier on professor, reiterated that court has disregarded its own precedents. Why? We can no longer even advise a client on the likely outcome of a trial once we are given instructions. In the case of Kiiza Besigye, which was reduced from 30M to 3M, this is what court held. Bail terms or conditions must not be set so high as to be out of reach or appear punitive. They must not be so low as to be outrageous or ridiculous. They must fit the circumstances of an individual case. He reduced that amount from 30M to 3 million. Come Eron Kiiza, 20M cash bail. No wonder the ruling was read by the registrar. I still celebrate that ruling because it was a human rights case, but with the reservations, if we are to admit it to the radical new bar, it should be with modifications. It doesn't fit the test. Let's also look at the case of Nicholas Opio, which we all still remember. He was charged with money laundering. It's a case number, criminal case number 106 of 2020. He was prescribed to pay 15 million. Later on, the DPP was to submit a NORE before court that he wasn't interested in proceeding with that trial. But for him to be released, he had to pay 20 million. And now it's the case of my learned senior, Counsel Eron Kiiza, to pay 20 million, which actually he paid. One, does it really fit within our constitutional dictates as far as human rights conditions could be concerned? I earlier on submitted that Article 23, Clause 6, A, B, and C subjects these conditions under judicial discretion to reasonableness. That's the discretion that is given within the Constitution. But all of us who have represented people in criminal trials, cash bail is always prescribed at the tail end. After you bring your witnesses, your sureties, You submit that this person is a first-time offender, has a permanent place of abode, unlikely to abscond. At the bottom, in the jurat of the judgment, the magistrate or the judge is saying, your client shall be released upon payment of this. Court hasn't investigated this person's capacity to pay this money. They don't know the worth of his estate. Leave out these cases of 20 million what? Leave the realities. I've represented people in Uganda on different arrangements, on pro bono, in most cases in criminal, and I spent most of 2023 visiting different prisons in Uganda, investigating the impact of cash bail. I realized that so many people are granted bail with a term as cash, and as such they fail to pay, and they remain incarcerated. That's one. One time I represented a lady in Kabela Maido. It was on pro bono. I actually argued with the judicial officer that they known to impose cash according to the nature of the case. And she counter-argued me that, you know what, always my prescription is not outrageous. She prescribed 100,000. 100,000 Ugandan shillings. This lady had to first tell the family to sell their goats to pay 100. To her, actually, even 100 is much more than 20 million that Eron Kiiza paid. That shows the general corrupts of this right and how the judicial officer handled it. Another person was given bail here at the criminal division, but he took something like 18 months to get 15M after selling his land in Luwelo, and the family was left indisposed. The family had been displaced from their traditional land where they used to get livelihood in order to rescue their father from prison. And we should not also forget the synopsis between crimes and poverty. So the majority urban youth are being prejudiced by this condition. However, judicial discretion is not absolute, because this was considered in different cases. When you check the case of Honorable Sam Kutesa and others versus Attorney General, judicial discretion is not a private opinion, humor, arbitrariness, capriciousness, or vague or fanciful consideration. Court must consider all that is before it, even the person's capacity to pay, which doesn't do. Some people do counter-argue that there is a right to revise. You can apply for revision. I always ask them on whose cost. A person who applied for bail, now you're saying if you want it to be removed, apply for revision. You're compelling these people to come before you, stand before you, and plead their poverty. That dear judicial officer who is being paid using our tax money, here I am, I'm poor, you prescribe that I should pay this, I'm unable. Please have mercy on me. But bail was granted in the first place. Let's look at mandatory bail briefly. That is Article 23, Clause 6. C. When a person has been in remand for 60 days, in cases triable by a magistrate court, or 180 days in cases triable by the High Court, qualifies for mandatory bail. I've applied for mandatory bail for so many people, and the court has prescribed cash as a condition. My question is always, why should this person pay? He has been available to be tried. The ineffectiveness and inefficiency of the DPP that he has failed to produce any evidence to allow this matter proceed on the trial is making this person to pay cash in order to be released. And many of them have left them inside because they are unable to pay that. So, and I submit that cash bail in its way, whether it's 1,000, whether it's 100 million, whether it's 20 million, is unconstitutional simply because court did not investigate the accused's capacity to pay. 2, bail is already granted because you have substantial sureties. Sureties have been bonded down to a specific amount. In Eron Kiiza's case, it was 50M for all the 3, Dr. Bike, Advocate Prima Kwagala, and Eron, his wife. 2, there is an option that a court can at least give you a non-cash bond, which you pay upon offending bail terms. Because if you're commanded to pay that, then you have offended. Why don't we allow sureties, the institution of sureties, to play its role and a non-cash bond? 3, I've earlier on alluded to the fact that the poor are marginalized under this. Let's look at Article 21 of the Constitution that prohibits any kind of discrimination. And once cash bail is prescribed, it basically mandates that you must be cash flow solvent. There must be liquidity for you to benefit from this grant. If at all it's not there, you're taken inside. So, but you find that if the same time is granted to a rich person, they just pay and go. Eron Kiiza paid and is out. As such, it's discriminatory to the poor within the listings of Article 21. And also recall Article 126, Clause 2, exercise of judicial power and how it must be done. To quote verbatim, in the adjudicating cases of both civil and criminal nature, the courts shall subject to the law apply the following principles. A, justice shall be done to all irrespective of their social and economic status. So if you prescribe for me cash and I don't have money, have you done justice to my status as a person who is not having money? As such, court has completely abdicated its duty as far as the right to access to the bail relief is concerned. 2, when bail is granted and you don't have money, you're taken back in detention. And various case laws in different jurisdictions have held that that is unlawful detention. To read a quote from the 36th President of the United States, that's long ago during the colonial days, or in the aftermath of colonialism, 1966. That is the President of the United States of America, by names of Lyndon B. Johnson. This is what he said. The defendant with means can afford to pay bail. He can afford to buy his freedom, but the poor defendant cannot pay the price. He stays in jail for one reason, only because he is poor. So the majority poor, like the Kabazgulka case, I remember the president, Isaac Semakade, highlighted to us the plight of people who were under military detention and trial in Kalamoja. That this case did not actually concern only Kabazguluka, or by that time the politically charged case of Kiiza Besigye. But how about the plight of the poor people in the Karamoja region who were under this kind of kangaroo court system? The very same way the precedents that are being set in Eron Kiiza's case and the whole plethora of cash bail is prejudicial to the majority poor. The per capita income of an ordinary Ugandan is $2. Imagine if you're earning $2, you have to feed the family, you have to feed yourself, and again, they tell you that pay 100. What is the international practice on this as far as cash bail is concerned? In the USA, we have 2 states. Ms. Aule has dealt with it all together. And there are different cases that have dealt with that. We have Dixon versus City of St. Louis. And their court observed that detainment solely due to a person's indigence, because the financial conditions of release are based on amounts beyond a person's ability to pay and without any meaningful consideration of other possible alternatives, is discriminatory and unconstitutional. The very same thing was also observed in the case of Donnells versus Harris County. So other jurisdictions are doing away with this practice. For us in Uganda, we are prescribing to 20 million for a person to benefit from this relief. Let's also consider prison congestion, because once people fail to pay, our capacity as prisoners of recent is 25,000 prisoners. But the statistics we are having over 75,000 prisoners, more than 100%. So why don't we reduce? Why should the judiciary contribute to prison congestion? International law. When you read Article 9, Clause 3 of the International Convention of Civil and Political Rights, it guides what these terms and conditions of bail should be. And specifically, being expounded under General Comment number 35, paragraph 38. This is what it says. The relevant factors to consider in determining releasing suspects on bail should be specific in the law and should not include vague and expansive standards. Prescribing 20 AM 15 word, that's vague and expansive. It should be specifically prescribed within the law. Then, as I'm winding up, does it serve a legitimate purpose? Because these bail conditions are intended to ensure that a person returns to attend trial. One, don't we have people who have been granted cash bail and they have absconded? I'll raise your attention to the case of Matthew Chilavo. that murder case that happened in the sugar plantation in Lugazi. Cash bail, but he absconded. 2, of recent we have reports that judicial is stuck with over 26 billion unclaimed money in form of cash. That was solicited because of cash bail. 26 billion, because you're entitled to claim this money whether you're convicted or whether you're acquitted, so long as you abided by the terms of your bail grant. But this money is not claimed. It's a clear explanation that money will not compel a person to come back to court, but rather the substantiality of the sureties and other factors. What is the way forward? Because I've painted a picture that cash bail and most of these terms are evil in nature, untenable in the modern dispensation of justice. And actually it's my argument that they should be dealt away with. 1, we have the conventional ways of how people do things. That is robbing, talking to the powers, and we have the table bangers. On the 2, what can work? There is no one fit for all, both can work. But I pay attention that on the 19th of April, 2021, a human rights organization called the LASPNet and ASF, Advocate San Frontier, conducted a meeting with the principal judge, Dr. Flavia Zeija, and presented a paper. That paper was entitled, Conditions and Practices Associated with Granting of Bail in Uganda by the Courts of Law. In that meeting, the principal judge applauded these human rights advocates and the like, the wonderful work they had done into that paper, and promised them that judicial was developing bail guidelines, that they are going to be invited for their input before they are officiated. These were the constitutional bail guidelines for Courts of Judicature Practice Directions 2022. Unfortunately, they were never invited, but the CJ released them. And 2, apart from cementing the checkered practice of requiring cash, depositing of titles and the like, nothing was done to ensure that the right to relief to bail is accessible. No wonder these constitutional bail guidelines are subject to a constitutional petition by table bangers, that is Stephen Kalali versus Attorney General, challenging the power of the CJ to interpret the Constitution using these directives. We are yet to receive the judgment in that matter. And there is also another matter challenging still terms and conditions of cash bail, that is Kuku Amos and 2 others, versus the Constitution, versus the Attorney General. The issue would be, we've always been challenged that you're bringing these matters, but you don't have precedents. Like, this is a thing that has been normalized. It has been here for long that you people, you feel is part of you, and it should be. You don't, like, we need to think beyond that to ensure that at least the public can access these remedies and access to justice. I draw your attention still to the observations by Lord Denning in Parker versus Parker. If something has never been done, are we going to just fold our hands and not do it? And this is what he said. What is the argument for the other side? Only this, that no case has been found in which it has been done before. The argument does not appeal to me in the list. If we never do anything which has not been done before, we shall never get anywhere. The law will stand still while the rest of the world goes on, and that will be bad for both. We said in the case of Kiiza Besigye, cash bail was exorbitant. We are still discussing it in Eron Kiiza's case, unless if we challenged it using all the available means, bang the tables, engage if the powers can pay attention to that to ensure that this practice is dealt away with. My conclusion, as I wind up my observations on cash bail, is I have highlighted that this element concerns all the Ugandans, rule of law, human rights. And so, where judiciary has paid indifference to our plight, where does it, they don't care. One judicial officer entertains a revision in 2022 and reduces 30M to 3M. In 2025, is prescribing 30M. They don't care. It's none of their business. They have made it all. They are on the top of the world. So it calls us on duty to ensure that these pre-colonial practices, colonial hangover, and injustices are dealt away with, using all the available means, because you never know when you shall ever be a candidate of such an injustice. Thanks very much.
Thank you very much, Advocate Amos. We are so grateful you have taken time to take us back to class with all those notes. Thank you for the research. We appreciate. Ladies and gentlemen, we are still together on the same issue about cash bail. We thank you. We take cognizance of the presence of the other panelists who we shall introduce later. Thank you. We also reminded that the panelists are open to questions. Kindly feel free, especially those online, do not hesitate to type your question and put on the screen. We shall pick them up and share with them. There will be a question and answer session after the first part of the discussion is taken by. Those in the house, you're also requested as well to get more information as you ask questions. Advocate Amos, we are very grateful as you recounted the unbecoming events of how dire the state of the judiciary is. We thank you also for giving us enlightenment, especially about how we should not be folding our hands in the dire state of the judiciary. We call upon the members, especially the lawyers, who especially this issue touches, to rise up and stand up for the nation, because the public and especially the RNB is here to help to bring out these issues. That's the purpose of these sessions every week. Please feel free. We also thank you for taking over from the professor's discussions, especially about the crisis that we are in regard to the disregard for court precedents. If the same judicial officer can make two different decisions within a space of 5 years, that leaves a lot of questions to be asked, as well as the colonial hangovers that we have listened to. Thank you so much. God bless you in all your endeavors. Ladies and gentlemen, we're still on the same issue, and we're not going to take so much of your time. We have one more panelist who is going to help us to break down once again the issue of constitutionality of the cash bail. With us, we're not going to take so much. The next speaker doesn't need so much introduction, but has already been a part of us and is part of us. He is an advocate and a seasoned legal professional with over a decade of experience in legal practice. He is a partner at Nangulu and Mugoda Advocates. He has built a reputation for excellence in legal representation and advocacy. His work spans diverse areas of law with a strong focus on access to justice and legal reforms. He is a holder of Bachelor's of Law from the IUIU and a postgraduate diploma in legal practice from the LDC. His career has been defined by a commitment to ethical legal practice, professional development, and the advancement of Uganda's legal landscape. He believes that a functional judicial system is critical to upholding the rule of law. Beyond his legal practice, he is passionate about strengthening judicial efficiency and addressing systemic challenges within the justice sector. His engagement with the Uganda Law Society, where he serves as the Eastern Region representative, has positioned him as a key advocate for improving access to justice, particularly in undeserved communities. In this capacity, he actively engages with legal professionals, policymakers, and stakeholders to explore solutions to issues such as case backlog, procedural delays, and barriers to timely justice. He is committed to fostering a legal environment where justice is both accessible and timely. His work centers on improving legal frameworks, advocating for professional development, and ensuring that legal practitioners in the eastern region of Uganda have a strong voice at the national level. Ladies and gentlemen, and the audience, please welcome with me Counsel Eddie Nangulu. Thank you.
Thank you so much. Good afternoon. Me, I'm not breaking down, I'm just wrapping it up. I hope you are well. I hope we are enjoying the discussion. Today is a unique day, and it's keenly unique because people who are speaking indeed are seasoned, and they're drawing from their own experiences. What I want to pick up from what was said by my brother Amos. Amos said they don't care to express the indifference of the bench. I have a tweet here from Eron Kiiza, whom we're even discussing. Eron says, this morning tweeted and said, detainees think more lawyers and judges should be detained or remanded in prison to have a real and first-hand feel of what detention is like, so they can better understand what is at stake when remanding and detaining other people. Now, those are deep sentiments expressed by Eron Kiiza, that until you walk the shoes of a person, you can never really express or understand what they are going through. I've heard the story from Amos, and in my own experience, but even before I even go there, we are taught, and this is maybe my brother professor, we are taught as students of the law that do not get attached to your client's case. Do not get drawn into it. Remain on the sidelines and be objective at that point. But you know, it is extremely hard to detach. It's extremely hard when they detain your client for frivolous reasons. It's extremely hard when rights are being abused and being denied for no real reason. And Amos was saying it is time for the table bangers to come out of wherever they are sitting, wherever they are settled. It is time that the banging must be louder, it must be often, it must be common. Now, in my own experience, I had a matter yesterday. My client, one of my, let me use the phrase pauper clients, I'm doing a pro bono for her. My client was, we applied for bail in as early as August 2024. When we applied for her release on bail, the court set a cash bail term of 1.5. Now, this is a pauper client who can barely goes by. So because she can't afford the 1.5, she's forced to remain in custody. Now she surpasses the 60 days my brother referred to. When we now bring that up before the court, that okay, much as you set these terms before, that were not applicable or maybe affordable, now we have this right now to mandatory release. And the court said, no, from what the record shows, your client is on bail. And having failed to afford to pay that bail, she would not enjoy now other rights under the Constitution. Now, this is a real and fundamental problem. It's a crisis, as Amos was saying. The courts are oblivious to social standing. Terms are set without appreciation of capacity and affordability. Now, when terms are set without being alive to the accused person's state of livelihood, it becomes unfair, it becomes unjust, it becomes a penalty. You're buying your freedom. Now, those penalties offend Article 28 on the presumption of innocence. We have been calling out and crying out against pre-trial penalties. It is a different form that the law has legalized oppression of accused persons. It is legal that the court shall deny bail, but where does that now leave your presumption? And when Eron says that it is time that the people at the bench also be remanded, it is time that they also be denied these rights. It is time that you also ask to pay a hefty cash sum. But then you would be able to appreciate that the right of the that one must be presumed innocent, primarily, before you indeed begin to condemn. Now that is just a general overview. Professor laid down elements of where he has discerned crisis, and I agree with him entirely. I want to just add that that crisis is largely a creature of corruption. There is a new form of corruption called judicial avoidance, that you'll have a judgment, you'll have a decision, but the court shall veer off key aspects of the law and your rights. A key example would be, my brother must say that the courts retreat to decorum, they retreat to formalities and to procedure, and deny obvious constitutional rights under the disguise of you've used the wrong procedure, you've applied in this manner, and they'll veer around the technicalities and deny meaningful justice. Now, in the Supreme Court case of on the court-martial, the crisis we face now is largely because of judicial avoidance. My brother was saying earlier, the professor was saying that the court ought to have retained jurisdiction and made decisions and gave clear guidelines on how to apply and enforce its decision. Now, having not done that, the lacuna that we are facing now, and even if you read the Kiiza judgment that we are now debating today, you will observe indeed how we arrived at this point because of the omissions by the Supreme Court. His Lordship Elubo was trying to veer around whether indeed he enjoys jurisdiction, whether indeed the Supreme Court conveyed jurisdiction, whether indeed he is able to offer remedy, and at the end of the day, he retreats to equity. Here is what he says. Here is one of his quotes. His Lordship in his judgment quoted and said, "The primary duty of the court is to do justice to all manner of men in all matters before it. It then seems to me clear that when the court sets out to do justice so as to cover new conditions or situations placed before it, there's always temptation, a compelling one, to have recourse to equitable principles. A court must be seen as a court of conscience, and judges who dispense justice in this court of law and equity must always be ready to address new problems and even create new doctrines where the justice of the matter so requires." Now, in his, and I would say rightly so, in his wisdom, where the law didn't offer recourse, there is recourse in equity. And again he says this: a judge that is confronted with a legal problem does not have to resign helplessly where the established laws are inadequate in resolving the problem. Colleagues and those who are listening, we must agree that we face a number of lacunas in our jurisprudence. When my brother Amos says that the table bangers must stand up, the bench equally must stand up. The bench even more than anybody else. Decorum and the omissions within the law. His Lordship Elubo could have easily said, we will wait for the parliament to enact legislation to accord us jurisdiction to offer redress to people such as Eron. Now, people such as Eron, beyond Eron, the persons you referred to, the Karamajongs who are in custody. Now, for those, they are seated and possibly awaiting for, I don't know, recourse from where. But His Lordship clearly says it and is more in this part which I just read, that when there is no recourse under the statute, equity should really offer remedy, because indeed equity would not suffer injustice and not offer any recourse to persons needing redress. As I wind up, the Supreme Court gave with one hand and took with the other when it determined the court-martial case. Why do we say so? And why have we, as the Radical Nuba, sought to contest that decision? I must first point out that we have indeed lodged, through our high-profile case unit, the Radical Nuba has filed reference number 14 of 2025 at the East African Court of Justice. That reference is to address the anomalies in the Supreme Court judgment, because unless addressed, those shall remain. Key among those anomalies is that the Supreme Court did not indeed abolish the practice of trying civilians in the military courts. It simply said, let a proper fora be set up so that trials can happen. But we know precisely how the court-martial has been operating. I don't know why our leaders have drawn away from setting up maybe a high court commercial division. They would want to return to their original spaces of oppression and abuse of rights, as had been previous and even as had been seen. They want to continue the traditional means of creating submission, mostly to political opponents. Now, we are saying that that is wrong, that the Supreme Court ought to have entirely abolished the court-martial. Number two, in addressing, in relieving civilians of the burden, I strongly think that even the soldiers that appear before the court-martial equally are entitled to justice, equally are entitled to a fair process. Right now, the transition and the transfer of cases is only for civilians, but the injustice doesn't recognize whether you wear the uniform or whether you're a civilian. You will be handled oppressively and you will be treated unjustifiably in that court there. Our third major concern is that the Supreme Court, in the prospective and retrospective annulment, the decision that annulled, if I may say it rightly, the prospective and retrospective annulment, the court's decision to apply prospective annulment ignores past injustices and denies victims access to effective remedies or even compensation. What this simply means is that Eron, Kiiza, or anybody else who is a victim of the court-martial has no recourse against the government of this country for either illegal detention or unjustified imprisonment or whatever would be unjust throughout the process. We feel this was a major miss by the Supreme Court. And lastly, it is the role of the DPP in these matters here. You are conveying mandate to an entity that you cannot control. It is almost 3 months since that decision, and we wrote to the AG to inquire about the files and how many have moved since the decision. We haven't received a response, but what I can gather is that apart from Kiiza Besigye and Eron Kiiza's files, everybody else has been either ignored or left unattended. Now, the DPP, of course, enjoys independence. Now, how far you can compare that these steps are taken urgently or immediately is a matter of is subject to a number of circumstances. For Kiiza, Besigye, and Eron, it's because of how vocal they are that they can have their files transferred as urgently as possible. But how about the rest? How about the rest of the Ugandans that were victims of the court martial? Now, as I wind up, for me, I celebrate the Eron Kiiza judgment, and we would indeed even want to thank His Lordship Elubo for carefully resolving a critical issue. He could have easily retreated to the traditional norms of decorum and offered no recourse. He stood firm, and we need to invite many of his ilk to rise up and stand on the right side of the rule of law. Join the radical bar, the radical movement, and the rule of law activists, demanding for justice, demanding for observance of the rule of law, demanding for freedom, demanding for fairness. I want to end on that note. The speakers who spoke before me had broken down these things as elaborately. I didn't want to repeat. But as I end, maybe one last remark would be the words that my brother Amos used. They don't care. They don't care until it happens to them. Until it is them that are burdened by these circumstances, they won't care. But if we must send a call out to the bench, it is important that they empathize with the plight of members and this country. You can't be withdrawn and detached forever. You can't be hiding behind the colonial principles and deny justice. It is time that we stand up. It is time that we administer justice, meaningful justice for this country and for our citizens. Thank you.
Thank you very much, Council Member, for that elaborate discussion. We continue to thank the RNB, the Radical New Bar, for lodging that case at the East Africa Court of Justice. We are very sure that we shall achieve that victory with the able leadership of the President and the Council. We continue to thank the panelists who are still here with us. We have not changed on the course of action. The Radical New Bar is here to espouse the discussions every week. We thank you so much for the ladies and gentlemen in the house. We thank you for those that are online. We are not going to relent. We shall continue to do this until the public also appreciates that we are doing the best that we can. We continue to also air out the cries of the public and keep saying, "O Uganda, may God uphold thee." Continue to commit the country into the hands of the Lord. We celebrate the judicial officers who continue to fight for the rule of law in their capacities, because of course not everybody is able to do, but there are those that stand out to do the same. Ladies and gentlemen, we've come to the end of issue number 1, and we had promised that there will be a very brief question and answer session that we received some 2 to 3 questions that go to the professor and Advocate Amos. One of them goes to the professor, and you will feel free to activate that microphone just before you. It reads, anonymous. Professor, you mentioned that the Supreme Court in the Kabaziguka case did not fully pronounce itself on certain key issues, such as ordering for a structural injunction and giving further directives. My question is in regards to retrospective remedies. The court did not give remedies to those who were serving sentences of military courts. Shouldn't we look at past convictions by the court-martial as potential miscarriages of justice? Should those cases be revisited? Please.
Thank you so much. I think Edmund has already touched on that issue. It's indeed an injustice, and I suppose it's one of the issues in the case before the East African Court. Weirdly, the court says something is unconstitutional, but for some of you, we are sorry, your rights were taken away, but there is nothing that we can do for you. I think that's not proper. And that's why I thought, of course, the court struggles with one problem. It thinks, one, we don't have sufficient information before us. The court also tries to, and engages in what my colleague here has called a judicial avoidance. The court thinks, if we make this blanket decision that all the trials were unconstitutional and whoever was affected should be let out of prison, then we are going to be faced with a crisis. Number one, we don't know how many people. Does it mean the jails are going to be emptied? It's also worried, does it mean that these people are going to bring claims against the state? Would the state afford this? So the court worries, expresses worries that should ordinarily not be their concern, because if something unconstitutional was done, then surely people should benefit out of that decision, and a state should suffer the consequences of an unconstitutional decision. Yes, I alluded to the structural injunction. I just want to draw your attention to an approach that was taken by one court, which was faced with an almost similar situation when the South African Constitutional Court pronounced, in the case of State versus Makwanyane, that the death penalty was unconstitutional. It didn't have information before it, how many people were on death row. And the court would not decisively commute the sentences, because what the court preferred was to commute all the sentences. But it was not going to give a blanket commutation without understanding how many years a particular person has been on death row, what were the circumstances of the circumstances that resulted into imposition. So what the court did, it retained jurisdiction, and it ordered the state, I think it took over 2 years for the court, for the state to gradually bring before court individual cases that have been commuted, and giving the court information on those cases. And indeed, the court was patient until the last case was commuted. That's when the court closed the case and it said we no longer have jurisdiction. So my proposal is that the Supreme Court should have done the same. That would have avoided the crisis we found ourselves in. That would have avoided the crisis that Justice Elubu tried to deal with. Thank you.
Thank you very much, Professor. Allen asks, but starts with a question, with a statement. Professor, you mentioned the UN basic principles on the role of lawyers and some international principles. What protection mechanisms exist, if any, for lawyers like Eron Kiiza, and how can lawyers be protected from such prosecution?
Of course, the way the legal systems organized, we have the national legal systems that have their processes. It goes up to the Supreme Court. We have guarantees, the Bill of Rights, etc. Those are the rights that we were relying on to apply for habeas corpus for Eron, same rights to apply for bail. But beyond that, there are other places that remedies can be sought. We just heard that the council has filed a case at the East African Court of Justice. That is one arena. Within the UN human rights system, we have so many procedures. We have the treaty bodies that have various mandates, like the Human Rights Committee can entertain cases touching on civil and political rights. We have the special mandates, etc., etc. But of course, some of those mechanisms, as much as they provide some remedies and would be the most suited to enforce the basic principles on the independence of the profession, They are a bit away from us. Access is a bit of a challenge also. They are a little slow. And then, of course, the remedies they give sometimes are not judicious.
Yes.
They are not judicious in nature and cannot be enforced. But of course, there are those that are now mimicking judicial remedies. The African Court on Human and People's Rights can be approached for concrete judicial order. There are limitations there. The time does not allow me to elaborate how those mechanisms work. There are benefits and weaknesses. They are there. They have some benefits, but they also have some weaknesses arising from, also partly from the nature of the international legal system and how it works and the limitations that it has.
Thank you very much for that. The next questions are for Advocate Amos. One of them, yes, there is a question in the house, please. It's okay, there is a microphone.
Thank you, the Radical Nuba. Thank you, Professor, and your panel for the elaborate presentation. I'm Baguma Richard Ruatoro. I'm a lawyer, I'm an advocate. I'm a graduate student at the University of East London, currently doing my module on international human rights law. And my research that I'm focusing on for my thesis is accountability. This question is really premised on the fact that Professor comes from academia and he's the only one who can save us in testing some of the things we see in other jurisdictions. You are all aware of what they used to call the justice case or the jurist case under international law in the Nuremberg cases, where judges were using the law to subjugate and oppress people who are not aligned to the Nazi doctrine. And I was thinking that, persuaded by the decisions, many of them that they were, there was even a talk of an offense of judicial murder in those cases. Why doesn't a good professor write a paper on it? Since we know that judges here have the cover of immunity, we try to have these matters filed in the regional and continental and international courts to see as a test case if anything can come out of it, so that they are also intimidated in their comfort that my name is going to go on CNN, and when they are looking for these scholarships and other benefits abroad, there's something tagging on their head and reputation. I thank you, colleagues. Thank you, Professor.
Thank you very much.
It is more of a comment than a question, but I can say something about it. First of all, Mr. Baguma, I'm not a professor of papers. You know, I'm a professor of action. So I would rather file a case than write a paper. Of course, I would do research for the case. But you touched on Nuremberg. One thing that I wanted to comment on, you'll be shocked that a certain percentage of people convicted for war crimes by the Nuremberg court were lawyers. I think one of them was even a professor of law. What does this teach us? It teaches us that merely being a member of the profession does not mean that the person is immune from being a perpetrator of injustice. And that is something that we need to watch. So it doesn't come as a surprise that in all sections of the legal profession, at the bar, we see lawyers that are perpetrators of injustice and that, lay the ground for crimes against humanity. At the bench, it is the same. But the most important thing is to call out those members of the profession. One of the approaches and which I've suggested is to have measures of accountability. And one of the most obvious one, and which, to use the language of NGOs, a low-hanging fruit, is to make the process of judicial appointments transparent. Other countries are doing it. That you are subjected to a public hearing. And if people think you are not suitable, then they call you out and detail what you've done before, which may be a bar for you to being appointed to judicial office. Yeah, so it's a question of using different methods of accountability. Of course, there's judicial immunity. We cannot sue them. That's the challenge. Although there are cases, jurisdiction where data has been experimented, we may want to experiment with that. But accountability is the key.
Thank you very much, Mr. Baguma. I hope that is good enough. There's another comment coming from online, from Tabs, related to yours, saying the attendance of each judge should be public knowledge so that we can gauge their level of seriousness. That is more or less the same thing. And the other, Abe Golova, says, why don't we have weekly roll call for judges? I think that is almost more like the same thing of accountability. Thank you so much once again. There's a comment from Philip who says, what a smashing presentation from Advocate Amos Kuku. Thank you so much once again for those that are online, that are paying attention to these discussions. We appreciate. The question for Amos again after that goes, the drafters of the laws had a reason behind creating a provision for cash bail, given that it ensures that the accused persons appear in court. If cash bail is scrapped off, won't we have more accused persons failing to appear because they got their release so easily? Won't this cause challenges in the criminal justice system, and how do we strike a balance? I hope that is clear.
Yes, thanks very much for that question.
You're welcome.
That the framers of the law had it in mind. One, my approach to that and the answer is, the rich and the powerful needs the law. The poor and the vulnerable needs justice. Those are two distinctive creatures. Don't we have other para-safeguards to ensure that accused persons do not abscond from bail? One, we have the institution of sureties. These sureties are bonded, non-cash, no problem with that, because by the time they are called on to pay, a wrong has already been committed. A person has jumped bail, or even non-cash bond, because at that time, a person has been in prison for over a year, for over 3 months, they are not working, but you're telling them that to be released, you have to pay this money. In the end, they become beggars. A court of law is reducing the citizenry into beggars to ensure that maybe they raise this money. We have the institution of sureties. And actually, if you do not have substantial sureties, even if you have more than $1 billion shillings, a court of law will not grant you bail. So I earlier on asked, what is the purpose of this bail? How come that judiciary is stuck with over 26 billion unclaimed? If we are arguing that it's always cash which is deposited into courts of law that compels these people to return during trial, how come that it compelled them to return, but they are not returning to claim it? Therefore, there are other underlying factors. Unless if at all the argument is, if you have money, you don't need to have sureties, you don't need to have a permanent place of abode, you don't need to prove that you will not interfere with the investigations, or you're not a danger to the community. So the whole element of cash bail is only having one element, commercialization of human rights aspects and commodifying the right to access to bail. It's like justice for sale, that present money and I grant you bail. Then, yes, I'm on record, but I would say off record, research has shown how non-cash bail has groomed corruption, bribery into the criminal justice system. Non-cash bail, in essence, lawyers know that is cash bail. So to avert all that evil, it's better we do away with it altogether, and we employ other means like substantiality of sureties. That's my take on that.
Thank you very, very much. We are really appreciative, ladies and gentlemen. We thank you once again for keeping attentive. There is a comment from Senior Counsel Henry Joseph Cunha online that reads, wonderful presentation from the panelists. Kudos to all. He says the bench should come on board and fully appreciate their key role in ensuring access to justice. After all, the accused persons remain human beings and are equally entitled to these rights. Thank you so much, Council. We appreciate as you keep to follow us. We appreciate as the RNB. Thank you once again, ladies and gentlemen. We've come to the end of issue number 1 or topic number 1. We want to appreciate those that have been the panelists for us. Could we please just give them a round of applause for their efforts? We appreciate. As we delve into issue number 2, ladies and gentlemen, that reads as a topic, the rise of online legal explainers. It reads the rise of online legal explainers. And briefly, just a brief introduction. We are living in a digital age where access to information is no longer a privilege for the few, but a right for all. And in the legal world, we are seeing a remarkable shift where young, passionate legal minds are harnessing the power of digital platforms to enable access to information for the general public. Therefore, this is a panel of legal educators who are bridging the gap between the law and the lay person. Okay. Briefly, may you please excuse me? We're going to indulge the panelists for a very brief picture moment before the professor leaves. He alluded to us that he would not be here for long, and to respect that, we'd like to kindly request that we take a very short moment of a picture moment for all the panelists in respect of what we normally do as our culture. Thank you so much. Thank you so much. Professor, once again, thank you very, very much. May God bless you in your endeavors. A continuation. Our topic number 2, like I had earlier on stated, is the rise of online legal explainers. And we are saying that we are now living in a digital era where access to information is no longer a privilege of the few, but a right for all. And in this legal world, we are seeing a remarkable shift where young, passionate legal minds are harnessing the power of digital platforms to enable access to information for the general public. Therefore, this is a panel of legal educators who are bridging the gap between the law and the lay person, promoting access to justice and empowering the public with legal knowledge. These young people have boldly embraced digitalization to make the law more accessible, understandable, and relevant to every day. To help to break this down, just as the RNB, one of the RNB 4Ds of digital transformation reads, we're going to have 3 able panelists who are all in the house. We thank you for your time. And the first is an advocate of the High Court who holds a bachelor's degree in law from the UCU and a postgraduate diploma from the LDC. She is the managing partner of Melki Advocates. She has previously worked as a partner at Bemanyisa and Company Advocates, and she is currently the CEO of validwills.net, which is an online platform dedicated to providing an affordable, fast, secure, and the easiest way to create a will for all Ugandans. Ladies and gentlemen, welcome with me, Council Mary Goretti Nakamia.
Thank you very much. That was a very tremendous welcome. I really appreciate it. It was a great introduction. I don't think I need to repeat it. I'll just continue from there. Mary Goretti Nakamia is my name. As they have said, I'm managing partner, military advocates, and I am the CEO of validwills.net. And today I'm here in that capacity of CEO of validwills.net. So someone may ask, what is validwills.net? So validwills.net is an online platform that enables a person to create a will effortlessly anywhere. You can be seated here while you're writing your will. You can sit in the kitchen. You can go over the beach. You can even sit in the toilet and write your will. So the website is validwills.net. And how do we come about this? This is something that I'm really proud of to showcase, because this is an innovative solution that empowers individuals to safeguard their legacies and protect their loved ones. How we come about this, I was with my husband and we talk about this. We realized we are handling by then so many cases of family and legacies, administrative causes. And when you handle these cases, you see that people are bitter about each other. Who takes what, who takes this, who takes what? And I'm like, okay, this is so sad, because I believe as a parent, while I am making all these plans, I am building these rentals, I am buying different plots of land, I am doing it for my own benefit and for the benefit of my children, because you cannot have everything and you can't use everything. So at the end of that day, when you're normal, you realize that your own children, because this is not something that children from different mothers or fathers, like people say, even children from the same mother, same father, fight over these properties. But this is something you as a parent, you as the owner of this property, you as a guardian, you as a custodian of these beneficiaries can deter. You can write a will. So that's how we think about it. Okay, now how do we make this easier for people? How do we make it possible for people to write their wills effortlessly? That's how we come up with validwills.net. So when you go to validwills.net and you log in that platform, you'll get information about the wills, because certainly you will understand that tomorrow is not promised. I believe every one of us here, the ones who are here in this house and the ones who are online watching us, everyone has lost a relative, either by sickness, long-term sickness, or sudden sickness, or an accident. This is not about age as people think about it. Unfortunately, in our country, when people talk about a will, they think that someone must be at that age of dying. However, it's not the same with me. That's why that platform is there. And it's not made by a person who is in their 40s, 50s, or in their mid-30s. I don't know. I think I am 29. So that's why that platform is there. It was created by someone who is within that age range, whereby someone may think I'm not thinking about death. But I've seen my friends die in motor accidents. I've seen people I studied with die over headache. And these people have something. Then I was like, okay, I think I have some property that I can leave to some people. So I believe this can go to my sister, this can go to my daughter, this can go like that. And I think then someone should be able to create a will. So we create this platform and someone can log into it. You create your account. When you log into it, you're able to create your own account and you fill in information that is there. Unknowingly or knowingly, you are creating a valid will, because the issue about here is creating a valid will. Many people are creating these wills and they think they are valid. Well, I'm here to tell you that not every will that you create is valid, because the law looks at certain features that it looks at as a valid will? Have you included all the beneficiaries, all your dependents, all the properties that you have? Have you given them out? Have you named your accounts? So unknowingly or knowingly, if you're not sure of the legal process, you will be able to create a valid will by this platform and telling you, fill in this information. Which land do you have? Is it titled? Is it, actually there is even Luganda version, and the Runyakitara is coming up, and Swahili version is also available. Is it titled land? I am asking you, have you disposed of all your property? Have you given your children? Have you named who are minors? Have you given them guardians? I'm guiding you and I'm telling you, fill in this. You put in a minor. It can even give you a feedback, like when you go back. You put in a minor. Can you create for this minor a what? A guardian. Can you name where you want to be buried? What do you want your burial to look like? Where do you want the funds to come from? These are all things that people think that when they are writing a will, you're going to die. How? I have a will. I've never died. I wrote my will so some time back. I think I've never died. And I think I'm yet to update probably next month, because I think I've gotten more properties that I need to include in my will. So this platform even enables you to update. Because you put in the other property before, you can still go back after like 10 months or 5 months. You're like, I sold off this property and I bought this one. Now this property goes. Or in 2 years back, I had 1 child. Now I have 2 children. I have to include another child. So that's how this platform is going to help someone who is either uneducated or educated. Surprisingly, and something that I find quite unfortunate, I think I've attended barriers for advocates and some who are my friends. So it's quite unfortunate that lawyers tend not to write wills. However, we are giving out this very legal expertise to people. So when you create these platforms, someone will be like, oh, probably this person wants to interfere into our work. I'm even helping you as a lawyer, because you're creating wills. You have over 50 wills for people in your docket. And among those 50 wills, none of those wills actually belongs to you. So are you saying that shoemaker, their children should not? Actually, we are fulfilling that proverb that shoemakers' children go barefooted. That's what we always fulfill, because as lawyers, we do not have wills. So what's that? So I'm encouraging even the lawyers, go to this platform. It's very easy. It's free to log in your account. Fill in your details, and it helps you fill in all the property. It gives you a check, the land that you have. Do you have any goats? Even those things that you think are minor, Any livestock, how many cows do you have? How do you want to give it? Like it just flows smoothly, seamlessly to help you do this. But if you do not visit it or you do not utilize it, then you may not be able to do it. You can even write your will at 3 a.m. in the night when you feel everyone is quiet. You do not want any noise. So it's funny that when you write a will, you will automatically think about death. But that doesn't mean that you're going to die. So if you feel that you need to go to the beach to write your will, go with your phone. Even with your phone, you can write your will. Go with your laptop to the beach. Sit down, seamlessly think through, how would you want? Think about when you're going to go. Because at the end of the day, tomorrow is not promised. And none of us is going to stay here forever. These are conversations that sound odd, that sounds weird, that are terrifying. But with validwills.net, it makes it easier that you will complete your will in like 20 minutes or 15 to 20 minutes on an average. 25-20, and you will not even feel that impact. And I believe at the end of the day, you will be very proud of who you are. So this solution enables individuals to be able to control their estate planning. How? I have children, and at the end of the day, when I die and I don't leave particular guardians and particular property that they're going to survive from, it may be a complex situation. Someone may think that my property belongs to them and they're the ones to give my children. Yet I am certain that I can give this property to my child, and in future she will get rent out of it. This is something that you can do, you as a person. Have copies of these wills that even other people will be like, oh, Mary Goretti said that her daughter Gianna is supposed to take over her property in Maya. And this property in Busega belongs to Gracia. That's how simple it becomes. You're not doing it for yourself, you're doing it for your even your beneficiaries. And at the end of the day, if you do not write these wills, and that's why we are creating these platforms for you, people are going to come and take the lion's shares in your estate, and these are the people that you may not have wanted. You may have a first child who you think should take something else, and she tells all the children, no. And then to share with you, to give you what you're supposed to take. So why are you causing these quarrels over sometimes you even have property that you can freely divide into these children, so that we reduce these case backlogs, we reduce the burden, we keep, I believe, to me, this is a solution that is created to reduce conflict among families. Because I believe even in the Bible, family is supposed to be united. This is our root. And at the moment you do not find peace in your home and in your family, you're running to the dogs. Who is going to be your family? So we, as people who are knowledgeable about this, please share this information, that this is available here. You know how to read Luganda. You can create your will anywhere. You can sit on your toilet and write your will in your bathroom, even put water to start flowing, so that you get that nice beach sound. So to me, I think that's all. If anyone has any questions on how the platform works, because it's simple, you just go, register, create your account, and then it's going to guide you. It will automatically guide you. Do this, fill in this, distribute. After you filled in all your property, it is going to show you how you're going to distribute your property. It will remind you that you've forgotten this child or this beneficiary or this dependent, and you may not sometimes be able to move to the next step when you've not done the other parts. Say you've not distributed some part of your estate. You will not move. It will tell you this property has not what? Been distributed, and you will distribute it. It will show you how you will distribute your estate, how you choose guardian for your beneficiaries, how you choose witness, where you put your witnesses in your will, and your burial. I might want people to on my burial to be putting on white, not black, not to cry. I might want music. So I put everything. This one is laughing. It's what I want. Surprisingly, I may not want people to shed tears. At the end of the day, I've made my day. So I'm like, you put music system. I've even have the money, and people's there. I tell this is the account number that you will pick my money from. So people do not just themselves looking for mabugo, condolence fee, what? I think we need to prepare. We may not prepare the same way our parents prepare us for us when we are coming into this world. I think we should prepare when we are getting out. The website is validwills.net. Thank you very much.
Wow, what an interesting topic. I was the one laughing because I don't yet have a will. I don't know if a council member from East has a will. I don't know if Amos Kuku has a will. And we are not that old as well. So yes, thank you so much. That is very important information that is facilitated by the RNB. We're here to try to help with one of the 4Ds, digital transformation. All this information can be gotten online, and the simplicity is you can use your phone to draft your will, and then of course get in touch with Marie Goretti to see how valid the will can be, in order for you not to have any worries in case of death. Of course, we have all experienced what you've said. Very many that we know who are departed have not had wills, and we ask ourselves, hey, how come with all the property? Now Mary Goretti has a piece of land for Gianna, and Gianna is already assured that life is going to be well after. Thank you so much. There's going to be a question and session answer very briefly after we've discussed from the other two. And we are still on the same course. Thank you so much, ladies and gentlemen. And those online, we appreciate the time that you've spared with us. We really don't take it for granted. Our next speaker is in the house. We're so thankful. She is a lawyer by profession with a bachelor's degree in law from the UCU. She is the director of partnerships at Law Point, Uganda, a digital law e-learning platform which assists law students, legal personnel, and the public to understand the law. Ladies and gentlemen, with me, please welcome Miss Cleopatra Abichira. Thank you.
Thank you very much for that introduction, Mr. Moderator. My name is Cleopatra Abichira. Like he has ably introduced, a lawyer and director partnerships, Law Point Uganda. I'm also an associate working with the Advocates. Yes, so Law Point Uganda. I'll briefly talk about Law Point and how it started. Law Point is a digital online platform dedicated to offering accessible, easy, and accurate legal information that people can access and find available from anywhere. So Law Point Uganda is started around 5 years ago. Coming to the outbreak of COVID-19, we had envisioned and started working by then as law students on how people could get legal information. We could see that dynamic shift in trends of how we were studying, how lawyers were struggling, even advocates, to find a case at your convenience, to find legal information relatively to your jurisdiction, or to something you can relate to in a simplified form, but also simplified, summarized, and quick to take you to what you wanted, even when you had no idea about what you were searching about. Because previously it was you had to know a case, then search for a case, or have a very clear idea of what you wanted. So our platform also encompasses not just lawyers, like what was there then, it goes to students, to people at the bar, and to the layman, to even a person who is looking forward to do law, but they don't have an idea of what they could read or of what, it's all about. It also goes on to mentorship. So that is how Law Point came about. I'll give a shout out to the founders. I know they're online watching, and our current team lead, Maria Nanyonga, Waboga David, who run this team every day. So we go to the inspiration of Law Point. Law Point mainly came to simplify the law. Yes, things are there, but can someone understand? And it's not about taking on the job of lawyers or other legal practitioners. It's about explaining and making it simple and easy, that even before a student goes to class, they have an idea, they can easily get what they're looking for. Before a layman walks out there, or if they've been told a certain concept or idea, they can read about it in a more simplified form. The nature of our platform is also very dynamic. We champion rule of law and constitutionality. We have had times where the first panel was discussing about, the bail cases and everything. So we saw it as a platform where young people who don't have the opportunity to go to court, or someone has an idea they can express in writing. You're still in law school, or you're not a lawyer, but you have something you want to say, you don't have time to go to the newspapers and everything. We usually call for blogs where people reach out to us, they write, and we actually present this information. But we also write, we look into these judgments and present our ideas, our thought, opinion. So we are at the backlog of all the people fighting, of the ideas that people present, but we present this every day. Then we also do mentorship. We do mentorship for young professionals, students who are rising out there. And we are also being mentored. We have a team of lawyers that actually guide us, that we look forward to. And we also appreciate the people that come online and comment and give, appreciate the work, but also lead forward and guide us. I will appreciate the president, even when he's not here, that he has been one of those people that have guided us and have recognized our work. I guess that's why we have an opportunity to stand out today as one of the legal explainers that have really stood out. I appreciate Counsel Philip Karugaba, whose guidance has been key and continuous in helping us grow as an organization, but also to all the legal students who come and express their opinions and write. We've written about a lot of key outstanding things, including the Attorney General versus the Kabaziguruka case that was presented and being discussed here today. We've been on several workshops as, that has skipped my mind, but writing and coming up with talking points. Organizations give us that opportunity and we are grateful. That is among the things that we do, and after that, we take out that information also for law students, for the public. We do legal clinics. That is our part of moving off from the online, and this gives students an opportunity to come that they may not have broadly in law school because it's for a particular class or because someone is not in practice. We've also seen an opportunity, a chance where you should not drop the law because you've finished law school and you're not working, you're not practicing. So people keep writing, people come for these law clinics, and it's a hope for many young professionals out there who do not have legal work that they're actively doing, but can get a chance to put their knowledge and skill out there under the guidance of people that they may not have a chance to sit under every day. So if you want to write, you have anything you're interested in, you can reach us, you can reach out to Law Point. Our email is lawpointuganda@gmail.com, or our website. When you go online and put in Law Point Uganda, the website will pop up, and you can send us a message, you can contact any number there. We've also seen, from highlighting cases and everything, we've also seen an opportunity where people are able to express themselves, where people are able to present things that they cannot present in their individual capacity, or we brought a seat for many young people who did not have where to start from. And from that, they've grown into making personal vlogs and advice and learning how to advise clients from the go. We've also had people reach out to us concerning very different things where they cannot reach, they have no idea of where to start out from, but they've seen our posts, they've seen the work we are doing, and we've been able to guide them. Work that you may not ordinarily do if you do not have an online audience or platform. So that is it about Law Point Uganda. We look forward, we are cooking a lot of products concerning activism and continuously using AI and embracing the digital era in the legal profession, which was previously considered very traditional and where it looked like you had to stick to a particular way of doing things in order to be successful. And we are glad that the RNB has embraced having the entire digital shift in the legal profession. Law Point has also enabled us to coordinate with, we don't just coordinate with people in Uganda, we coordinate with law students and lawyers across the world, and this has been helpful to many young people. They can easily access cases from other jurisdictions. You can discuss with them even when you've not traveled there, which for me is a deal breaker and has been very significant in shaping young legal minds. Thank you very much.
All right, thank you so much, Ms. Cleopatra. We appreciate your input and your time. I have personally been a beneficiary on X. I think I've accessed your information. It's very helpful for those that have seen Law Point Uganda. This is them, courtesy of the RNB. We keep continuing to thank the RNB. We thank the people that you work with, Maria, David, and Senior Counsel Philip Karugaba. We appreciate, as you watch us online, we appreciate. And also, of course, without saying much, the president of the RNB, Senior Counsel Isaac Semakade, who is here with us in spirit. We thank you. We're still together on the same point. We shall ask the questions after. We are getting to the close end of what we're doing today. And our next panelist is very passionate about the rule of law with a very strong commitment to human rights, constitutionalism, democratic governance, and social justice. He holds a bachelor's degree in law from Makerere University. He is also the founder and team lead of Lex Amica Limited, a youth-led non-profit organization that promotes constitutionalism and human rights through research, advocacy, activism, discourse, and education. The organization uses a combination of physical interaction programs and digital tools such as social media, artificial intelligence, infographics, animations, trivia, and quiz platforms to democratize access to legal information for every Ugandan. Ladies and gentlemen, with me, welcome Harry Mwesigwa. Thank you so much.
Thank you so much for that splendid introduction. Okay, so I'm going to speak a bit about Lex Amica, the organization that I'm representing here today, and also wrap up the conversation on democratizing access to legal information by use of digital tools. But first, I feel that we need to have an appreciation of the context in which we work, or the context in which we operate as Ugandans, and the context of the law. So allow me to take you a bit back by use of a bird eye view into history. So we all know, assuming that most of the people here have had a bit of interaction with Ugandan history, but also legal history in particular, that the initial understanding of law by the Ugandan was custom, yeah? Customs were the law of the land, and customs were quite easy to understand. Why? Because they were delivered to us by the chiefs, by the clan leaders, by the elders in the family, use of parables and all these things. So because of that, every single Ugandan or every single person in pre-colonial Uganda knew the law. They knew how to change their context, change their conduct in line with the law. They knew how to accustom themselves to the law. They knew what was prohibited, they knew what was permitted. And then we come in with the colonial imposition of the law through the 1902 Orders in Council with their reception clause and the repugnancy clause. We realize that the 1902 Orders in Council bring in the European version of the law, and that is, it is imposed on Ugandans or imposed on the natives, the inhabitants of these lands, by use of the reception clause, that the Indian Penal Code Act, the laws of England, and all these laws were received and became the laws of the colonial government. Second, we had a repugnancy clause in that document, which provided and stated that all customs could only be permitted in as far as they were not repugnant to moral justice or even conscience, which was really an English standard, really. So the African version of what we understood as law was immediately extinguished. It disappeared because customs could no longer be realized. We know of the famous case, Ara versus Amkeo, where it was stated that an African marriage could not be recognized because it was akin to wife purchase, and therefore it could not be enforced within the courts. So in that version, the African could not understand that law. It was a bifurcated version. It was a colonial imposition. It was a version of the law full of technicalities, full of procedural rules, ideas like locus standi, full of Latin terms. And this is the law that now translates into the current day-to-day. Because of that, you'll find that law it moves from being a public good in pre-colonial Africa to a product of the few, a product that is commercialized by lawyers, a product that is highly alienated or even hidden from the ordinary Ugandan. You'll go to a lawyer and they will tell you recipsa loquita. They will tell you all these other Latin terms, quid pro quo, and all this. And the ordinary Ugandan does not understand that. The ordinary Ugandan does not understand how someone can kill, but it is not murder. They are not guilty of murder because they did not have the mens rea, which is the guilty mind. So all these other principles become alienated, and that is where we now begin to have theories like lawyers are liars. You get it? Because the ordinary person does not understand the application of the law. Now, Lex Amica comes in to remedy that particular issue, and that is democratizing access to legal information. Because legal information is not only something that a few people should understand. Legal information is not like medical knowledge, for example, which is a preserve of doctors and you'll go and they overcharge you. Legal information is a right because it runs into, legal knowledge and information is a right because it runs across all sectors that any single person can interact with. Firstly, we have the Constitution. The Constitution involves the Bill of Rights, which are supposed to protect the citizen against the excessive or arbitrary conduct of the state. We have all these things. Rights are inherent, freedom from torture and inhuman treatment, how to enforce these rights, how to stand up and protect these rights, how to even promote accountability within the systems of government. But if that information is hidden from the ordinary Ugandan, they cannot be able to enforce their rights, or even they cannot be able to fulfill their role as good citizens in order to promote the social contract. And that is to keep government accountable and to ensure that government operates according to the dictates of the law, as we have seen a total erosion of the law. But it even becomes worse in that currently you will see that the legal education as it is premised is a preserve for lawyers. You have to go through law school, study for 4 years, then you go to LDC, and then they teach you all these other things, and you gain the knowledge, but the ordinary person near you cannot get that knowledge. So Lex Amica comes in to present legal knowledge and to present constitutional knowledge in a simplified manner, so that every single Ugandan can be able to interact with it, so that every single Ugandan can be able to understand it, so that every single Ugandan can be able to enforce that law for themselves, or to know how to achieve a remedy when their right or their freedom has been violated. How do we do this? We use various digital and online platforms to promote constitutionalism, to promote the rule of law, and to promote human rights. Firstly, we have animations. So we know that we are currently in a digital age where short videos can easily capture people's attention, and people can easily watch these short videos to be able to pick a concept. For example, we have TikTok. TikTok is a mushrooming platform, and most of Ugandans will have a TikTok account. If I was to do a survey here, I'm sure that about 90% of people would raise up their hands and affirm that they clearly have a TikTok account. So we produce animations, and those animations are talking about a particular article of the Constitution. For example, Article 1 speaks about the sovereignty of the people, that the people are sovereign in Uganda. What does that mean? We break that down into a simple, small explainer video, and then someone can read it and get a glimpse. When someone is able to understand that, our hope and our belief is that they can act on that information to be able to enforce it, or even to be able to promote their rights in a different way. Because we are in an era where there is total erosion of constitutionalism. I cannot speak like we're in a democracy. There is judicial apathy. We have been speaking about judicial corruption, judicial avoidance, even judicial incompetence. We have an unrepentant executive that lives and breathes on the abuse and violation of human rights. And because of that, you will find that the only remedy, or in most cases, the only remedy that people have is citizen agency. That they have a constitution that has been amended multiple times, to the point of non-recognition currently, but that constitution still has certain provisions, it still has certain rights. There is international law which sets the standard of rights that they should have, knowing that rights are universal, inherent, indivisible, and not granted by the state. Therefore, we know that if we give people this information, they can be able to act on it in regards to citizen agency to enforce these rights or even to uphold these rights. How does citizen agency looks like? Citizen agency can be in the forum of public interest litigation. That is one, but it is not limited to that. Citizen agency is radical and involves the banging of tables everywhere, where it is banging tables on the streets, whether it's banging tables in boardrooms, whether it's banging tables in public forums and in public meetings, like right now. So, when someone knows that I have a right not to be discriminated against, they can stand up when they see another person being discriminated against, having understood what is discrimination, and how is discrimination, for example, different from affirmative action. We've seen an example, for example, how citizen agencies stood up against the trial of civilians in the court-martial when Dr. Besigye was arrested, and that culminated into the Kabaziguruka decision, and even the current advocacy that is ongoing by multitudes of persons and organizations, including the Radical New Bar. So our work at Lex Amica is to provide that information so that at the end of the day, every single Ugandan can stand up for their rights. Every single Ugandan can tell a police officer that, you know what, you have no right to impound my vehicle at this instance, because I have this right and you can only impound my vehicle under this particular framework. Every single Ugandan can stand up when they see someone being tortured, someone being abused, and they say, I'm going to record that, and I'm telling you, you have no right to do that. It is that kind of agency that will cause this dictatorial government, or that will cause the various human rights violators that we have to shudder. Currently, we see the retaliation of citizen agency by the Radical New Bar, where the use of outdated and colonial concepts like contempt of court, you get it, yet actually, for example, people are working within their bounds of freedom of expression. So there might be retaliation, but that in itself does not stop citizens from rising up to protect their rights. So what other tools or digital tools do we use as Lex Amica to achieve that broad vision that I've been speaking about? The second thing that we use is reporting and documentation. So every single month, we produce a report about the state of constitutionalism in Uganda as regarding that month. And we publish that report and also discuss it. So we look at all the violations. If, for example, in the month of March, we had JAT beating up people in Kawempe. We had the unconstitutional deployment of the UPDF abroad in South Sudan. We had, for example, a supplementary budget which was excessive and is only putting a dent on the consolidated fund. Our work is to chronicle and document those violations so that if there is a researcher coming out tomorrow or someone who wants to do public interest litigation on the issue, they can come up with it. Individually, we also try to protect the right of access to information and the right to a democratized access to legal information. I have worked with my colleague, Counsel Kuku Amos. We have a case currently pending in the High Court which challenges the action of the Uganda Law Reform Commission to sell the 7th edition of the Laws of Uganda at exorbitant prices. Because they produced this edition, we know that law is a public good and law is not copyrightable. However, they produced an edition only in physical print, and then they began to sell these copies at hefty prices. And a Ugandan in a village cannot access that. Yet when he's arrested the next day, they will tell him ignorance of the law is not a defense. Third, we have infographics. So infographics are just these simple explainers in a virtual format that can explain to someone what a case is about, that can explain to someone what legal remedy is available, that can explain to someone, for example, if JAT uses or wears these hooded things, balaclavas, and then they go and they beat up people on the streets and the CDF is defending them, is that really acceptable and is it right in law in regards to the right to access an effective remedy. Should police be hidden, or should police move with masks when they are enforcing the law? Is that really the provision? So we explain and we call out that unconstitutional and blatant violation of rights. And lastly, we seek to do all these things in order to achieve accountability. And the accountability that we are achieving here is empowering you with knowledge of the law so that you can rise up tomorrow and stand up for your rights, so that you can educate someone tomorrow and tell them that, you know what, torture is impermissible, it is unacceptable, and there is no single exception to it. It is also to make sure that we help Ugandans to understand these rights. There are challenges that this kind of work brings, and this is how I wrap up. And it feeds into the decolonization that I started with. Because people have for a long time looked at law as something that is alien or something that was imposed from the West, even when you bring discourses to try to explain to them or for them to try to understand their rights, there is that initial reluctance. For example, I will recount a story where we're going to various schools, secondary schools, to teach them about their rights. And then, when we went to these schools, the head teachers met us and they said, what are you going to speak to our students about? We said, human rights. Human rights? They were like, you people, aren't you the other people of LGBTQ? Because every time we hear human rights, we know it's those people of LGBTQ. You get it? But yet you're coming to tell someone about the right to health, the right not to be tortured, the right to all these things. So there is still work in regards to democratization and also decolonization. But legal education, as I wind up, is a human right, and all the organizations today, the Wheels, Law Point Uganda, and even Lex Amica, works in the digitalization space to reach as many people as possible who are using digital services, to inform them, teach them about their rights, so that we can improve access to justice. Thank you.
All right, thank you so much, ladies and gentlemen. We thank you, the presenters, for very eloquent discussions, very young blood in the house. We want to thank you for making time and looking for that opportunity. It's both a marketing tool, but also a very important aspect that is helping us to understand what the RNB does as enshrined under the Uganda Law Society Act in Section 3. It's our mandate as well to elucidate and educate the masses about the laws and the rights that they have therein, and also as enshrined in the Constitution of Uganda. For example, legal education is also a right. Thank you so much, Harry and Cleopatra. We thank you. We are welcoming questions also from the members in the House and also those online. We take cognizance of Senior Counsel Philip's commendation, saying thank you so much, Mr. Moderator, and Cleo for the compliments. Thank you once again. Can we also give flowers to the indefatigable Joel Wegoye at Yuli? Okay, Joel Wegoye is a magistrate, His Worship Joel Wegoye, with whom the RNB has been in constant touch in regard to legal reporting. He works with the Uganda Law Information Institute, that is at the JTI, Judicial Training Institute. He has been very much a part of our cause, and he's a partner in what we do in regard to legal reporting. And also, let's not forget Anthony Natif. Yes, that's a social media personality who is very much present on social media in regard to helping to espouse and give information to the public. We are very, very grateful. RNB it is, and we are not going to relent. Like we have said, it's our mandate, and we are trying to see to it that regardless of age, regardless of where you are, the RNB, in conjunction with all the partners, especially the legal educators who have been here with us, are going to do as much as possible to see to it that our mandate is fulfilled. Ladies and gentlemen, if there are any questions, we are welcoming them. Those in house, yes, please.
Thank you so much. My question goes out to Mary Goretti. Thank you for the wonderful presentation. And my question is specifically in regards to, should I say, admissibility of the electronic wills. You talked about how there is that provision of updating your will. And I'm looking at a scenario where, let's say, someone has updated their will, but they've not had the time to print it out and, you know, maybe leave it with someone. What happens in such a scenario where they pass away and yet this information is still electronic? Because I know that the court has been quite, should I say, reluctant in regards to, you know, things to do with admissibility of electronic evidence, especially when it comes to wills and, you know, things to do with those death confessions, yeah? So in this particular scenario where there is the electronic wills, what are we doing to prepare our courts to accept such as evidence? Thank you so much.
Thank you so much for that question. That's really a valid question. Actually, you asked it and I realized that I missed out on a lot of information that I didn't give out. When you create this will, there is a provision for electronic signing the will. So you're able to sign and you're also able to give copies to your witnesses to sign. They can sign electronically or you print. So you have an option after you have printed and signed, you can re-upload it for purposes of storage. So in case a will is complete, is fully endorsed, it has been signed by your witnesses and you yourself, it can be admitted. I don't see any reason why it will not be admitted. When this will is created, it automatically comes with a QR code, like a special code. Each will comes with an ID if it's generated on the Valid Wills platform. So in this, even when someone has a copy of your will that may not be fully endorsed, as long as you uploaded a fully endorsed will on our platform, if they give us that will ID or insert in that will ID, when that person is no more, they'll be able to access a full will that was signed. But if it's not fully endorsed, then there is no way the courts will validate it. It's the reason we are helping you to show you what is required in our valid wills. So it's not just for a show, it gives you a guideline on what a valid will is. So each will has to be endorsed. The moment it's endorsed, I don't think the courts will fail to accept it as a valid will, because it will have signatures of your witnesses and the signatures of the person who endorsed it. So there's that other option, like I've discussed, of a will ID or a QR code to help your beneficiaries in case they're doubting a copy that is produced out there. They can receive that copy online if they have that will ID or QR code that is automatically generated. So any of the people who have a copy of that will or any of the beneficiaries will be able to actually validate that will, that, oh, it's indeed a valid will that from our either father or mother or auntie. Thank you. I hope I've answered your question.
Okay, thank you so much. There's another question here.
Yes. So good afternoon to everyone. I'm Council Tobias. My question goes to Council Kuko. You gave a very nice submission, and I would love to find your opinion on this question. What is your take on the promotion of judges from High Court to Court of Appeal, but some of the judges have faced, people have, okay, like indeed their judgments have failed and have been appealed to the Court of Appeal, but they have promoted them to the Court of Appeal. So what is your take on that? Because I've seen several cases, including the recent one of Isaac Semakad. It's in Court of Appeal, but the same judge that gave a judgment and is almost a party to the case is also going to the Court of Appeal to handle the same matter. So what is your take on it, and what are your suggestions on such cases? Because we have seen judges failing to excuse themselves from such matters. Having a matter concerning you and even deciding on it. So what's your take on that? And please, you can also give us your opinion and also recommend, give us some recommendations. Thank you.
Yes, thanks very much, Council Tobias. Judges being promoted into courts where their decisions are being appealed to. Of recent is a serious conversation between the contendants of representing the bar into the Judicial Service Commission, and also cases that have stifled the operations of the bar. Really, these are not normal conditions as far as rule of law, judicial independence is concerned, because what we are seeing is an overreach of the executive into the arm of the judiciary. Essentially, we are not having judicial independence, but we are having judicial dependence. Picking a riff from the very case that concerned Eron Kiiza, his bail application, I observed that Justice Elubu is the very same person who revised the decision in Kiiza vs. case. And he reduced 30 million to 3 million. A bail application is presented before him, and he's prescribing 20 million. Very same judicial officer. The underlying question is, whom was he appeasing? What was at stake? Do they have other powers to appease rather than the law? Are judicial officers servants of the law? So it all goes back to the modes of operation at the Judicial Service Commission. How do they appoint judges? How do they promote them? I want to believe that judges who have been promoted to Court of Appeal, some of them shall have the audacity of recusing themselves on matters that concerns them. But that is still not guaranteed, because we've just received a judgment where a judicial officer himself was the complainant and the judge. He was the witness, the complainant, and the judge. The decision is being appealed against, and he's into that very same court. So what will be the outcome of the appeal? Still time shall tell, but we want to believe that sin shall take the day and they will recuse themselves. So my opinion on that is to hold the stakeholders accountable. Those who are responsible at appointment of judicial officers, Judicial Service Commission, how do they appoint? Of recent, a member of the public applied for the record of proceedings, the minutes that led to the appointment of the current judicial officer, and they objected that they were confidential. The very same scenario arose in the appointment of the retired DCJ, Stephen Kavuma, and actually a case went up to the Constitutional Court, where actually I remember he refused to recuse himself still. But they couldn't release such information to the public. So these are not normal conditions. We must be ready to face it if we are to redeem the judiciary. The judiciary itself requires our services. How? We must ensure that indeed it reclaims its space. It must be independent, and it's we, the public interest advocates. It's we. The duty is on us. That's our take. And if we leave them to operate in such a shambolic view, we prepare for the road. Power shall ride naked, because there shall be no difference between the executive, the judiciary, and the legislature. Of course, there are rumors that Parliament is about to pass an amendment to the UPDF Act, subjecting the civilians to the General Court Martial again. There is a reference before the East African Court of Justice challenging the actions of the CJ in the Kavazgluka case. What a shame that a High Court judge in the name of Justice Elubu Michael shall have to educate the Supreme Court that, look here, under the law you do not have the mandate to grant jurisdiction on the court of law. What a shame that the highest bench the Supreme Court shall be informed by the High Court that jurisdiction is a creature of the statute. Shall we ever get a benefit of them departing from that ruling? I beg to submit.
Thank you so much for those brain teasers and very much for the questions. We thank you, Tobias, Council, and Baguma very much for gracing this occasion. We don't take it for granted that you're here. Thank you so much. Ladies and gentlemen, we've come to a close of today's session, and we cannot thank you more for your presence, for sparing time to be with us. The RNB is so grateful. We bless you very much. We thank the panelists, Mary, Amos, Cleopatra, and Harry. Thank you, without forgetting, of course, the one and only council representative from the East, Eddie Nangulu. We bless you. Thank you so much. As we come to a close, I would like to invite the head of comms, who is our very own Adam, who has a word or two for us before we can finally invite council member from the East to give us the closing remarks and a vote of thanks towards the end of this day's session. Adam, thank you so much once again.
Thank you so much, the moderator of today, the vibrant Jurua. That's very nice of you. Ladies and gentlemen, I want to thank everyone for attending this 13th series of our press and public engagement with the Radical New Bar. I don't want to delay you because I know that the inside needs what is in the pot. So I will try to be as brief as possible. But I would like to thank people here, and particularly, I'm a scholar of literature, and in literature there is something we call reminiscence or flashback, which we say sometimes it sets the precedence for denouement, the resolution at the end of the plot. And we have our back on track think tank, Madam Council, Madam Goret Nakamia. I would like us to really clap for her. Council Nakamia gave her maiden TV interview at NBS the day after Back on Track and the Radical New Bar had taken mantle as the spokesperson of the Back on Track. So to understand the gimmicks, I found out she is our think tank. So when she's talking about her wills and Madam Nakamia may have not yet got that property, that big property to write the will, but I heard that you are employing people and you want people for Nyachitara, and I am here. I can also take on that. Okay, but thank you so much, Council Goret Nakamia, for always supporting the RNB. I can say that we do not pay you. May have never signed a check personally to pay your efforts, but I think God is going to pay you. Then, the Council Kuku, you have always been my friend. Thank you for coming, and I can see, I think the payment you have got are those emojis I'm seeing online. I think that is the only payment you can take. At RNB, for us, we don't have money. You come and you speak to people and the nation, and you spark off the engagement with the Radical New Bar, and you take people back on track. So Council Cook, afterwards, don't take me to corners. Okay, I cannot, of course, fail to thank our most perpendicular council representative to Eastern Uganda, Council Eddie Nangulu. He's a mentor. He's this agile guy that we say we are very blessed to have on our council. Thank you so much, Council Eddie. Thank you so much for traveling from Eastern Uganda, and you come here in this short while. Thank you so much for holding fort. Our most perpendicular council, the top cream, they are currently in Malta, and they are representing the Radical New Bar at the Commonwealth Conference. Our partners Thank you so much, Law Point Uganda. We had you in 3 weeks of the Rule of Law Week. Law Point partnered very well with us. Thank you so much, Council Harry. I know you're a very good friend of our president. And at this time, I want to also inaugurate you now, immerse you in the radical new bar. Thank you so much for being there for us. Guys, that's why I stood up to thank these people. And I request that we stand up and give them a standing ovation for their coming. Thank you so much. A standing ovation is clapping when we are standing. I thank you so much.
Thank you so much. Without further ado, allow me welcome Council Member from the East to give us closing remarks and a word of thanks so as we can wind up in today's session. Thank you.
Wow, in just a minute, the thanks have been overly stated. I don't want to take any more time. Council Mary, you've been one of our backbones. Thank you for coming. Thank you for being around. Thank you for standing with RNB all through and through. We are here until 2060. Council Amos told me that he began the radical agenda long before our ideas were being conceived. Thank you so much for joining us today. We are indeed humbled, extremely humbled. Thank you so much. My brother Harry. Harry speaks freely, eloquently, like one of those young missiles that you can direct and fire at a meaningful cause. Thank you for joining us. Thank you for partnering with RNB. Thank you for what you're doing. It is really humbling that what Amos told me earlier is that now the young people have come out and the young people are now taking charge and are setting the pace for tomorrow. Indeed, it is good that you come out and set the pace. Then lastly, my dear sister Cleopatra, thank you for standing up, Thank you for what you're doing at Law Point. We're indeed humbled that we are partnering with you people to disseminate information, inform the public. And to our audience, our listeners, those that are physically here, those that are following us online, the media, our team at Secretariat, our council members online, and each and every one of you. Allow me to say thank you for following RNB Weekly Live. We shall be here again next week, same time. Have a good day and a good weekend. Thank you.